Good morning, class. Hey, this is Mr. Stewart, and this is going to be the Chapter 4 Integrity Lecture for CRJ 130. This chapter will cover state courts. And just like in the other chapter, there's some information that's in this chapter that you need to read and you need to understand, but you don't necessarily need to commit it to memory. What I'm most concerned with in this particular chapter is you understanding the structure of the state court systems, issues with jurisdiction. We'll talk about that here in a little bit this morning, and basically what the limitations of the state courts are, types of cases they can hear, and types of punishments they can hand out, as well as different types of state courts, such as the difference between the juvenile courts and the adult courts and things of that nature. So, with that being said, I want to give you a little bit of a heads up. Starting next week, which is the week of September, 15th, I believe, starts on Monday. I'm going to be out of town starting on the 17th, and I will be out of town until the 20th, which is Saturday. So I'm not going to be able to be on the course from Wednesday until Saturday of next week. I'm actually going to the Southern Criminal Justice Association conference at it's terrible, but it's in Clearwater Beach, Florida. So I'm heading down to the beach for about 3 days for work. So that being said, one thing to make sure that you do is take the first exam, which will be due next week. It will be posted by next week as well, so you should start seeing it Sunday night or early Monday morning of next week, and you'll have all week to get in there and take that exam. It will be 50 multiple choice and true-false questions, so make sure you get in there and take that test, and then also make sure that you get your usual weekly work done. Then I will get caught up on the grading and such when I'm back. Okay, let's get back to Chapter 4 here for just a minute. Chapter 4 has to do with state courts. Now, the first part of this chapter really gives you kind of an idea of the history of courts in the United States. It talks about the colonial courts. It talks about early American courts. And then it talks about kind of how courts have evolved into modern courts. And that's all fine and good. I want you to understand the history so you know why we are where we are today. But I want to start focusing on jurisdictional issues of the courts. You have two types of jurisdiction, or two types of courts with a particular type of jurisdiction at the state level. You have courts of limited jurisdiction and courts of general jurisdiction. Now, a court of limited jurisdiction is typically a lower court. It is a court that as it states in the title, it has very limited powers. They can only do certain things. An example of a court of limited jurisdiction might be a municipal court or a city court somewhere. I know when I was chief of police, we had a city court, and basically the only thing the city court could hear were traffic infractions that happened within the city limits that did not involve an arrest. So basically, if it was a ticket that I wrote, that could be heard in city court. The city was able to obtain the revenue from those court costs and such and so forth. But the city judge also could not put somebody in jail. He could only assess a fine up to a certain amount, and so what that court could actually do was limited in nature. And it's also called, courts of limited jurisdiction are also called, they're not considered a court of record, which means you don't necessarily have a criminal record if you get convicted of something in a court of limited jurisdiction. Now, some of them you might, but more than likely, if you get convicted of something in a city court, that's not something that's going to go with you forever. It's just going to be something that maybe somebody could find if they did a local records check on you. But because it is not a court of record, it's not really something that necessarily gets reported to the FBI as a criminal conviction. The next type of court is called a court of general jurisdiction. Now, courts of general jurisdiction basically have a much more wide range of cases that they will hear. They will hear cases in which people received citations. They will hear cases in which people were arrested, mostly the criminal cases. And they also are a court of record, which means if you get convicted in a court of general jurisdiction, you now have a criminal record. It follows you from this point on. These are what we would consider to be a trial court. Let's say you got arrested for DUI in the city of Huntsville. You would go to a court of general jurisdiction because that would appear on your criminal record and your criminal history if it were ran by the FBI at some point later. If you got convicted of theft, if you got convicted of robbery or rape or murder, all of those things would be heard in a court of general jurisdiction. They also have more power to punish, which means they can put you in jail. They can assess a hefty fine. They can even impose other sanctions on you that the lower courts of limited jurisdiction just can't do. Now, I want you to understand that the state court systems, or the study of them, is much more complex than that of the federal system, because the federal system is the same everywhere in this country. But because we have 50 states, plus the District of Columbia, plus a couple territories, we have more than 50 different state-type court systems in this country, and all of them are just a little bit different in the terminology and the function and the titles and names given to the courts and their powers and such. So, unfortunately, in this type of class, we can't simply go into great detail on what every single state does, but what we're going to kind of try to cover is kind of the framework of that particular state court system, and that's what we're talking about with these two types. So you have courts of limited jurisdiction and courts of general jurisdiction. So make sure you read that section in your textbook as well. There's also a small section on page 87 in your book that talks about civil cases. Understand that typically courts of general jurisdiction will hear civil cases. For example, if somebody sues somebody else, if they file a lawsuit against someone, then that is a civil case. The standard or burden of proof is not nearly as high in that case as it is in a criminal case, because you don't go to jail if you lose a civil case. You simply have to pay money to somebody as damages. It's a civil wrong. It's wrongs against each other, or wrongs between entities, or between people and entities. For example, if I sold you a junky car and you sued me because it broke down on you as soon as you bought it, chances are you wouldn't win that lawsuit. But if you sued me, it would go through civil court. If I lose it or you lose it, neither one of us would go to jail. We'd simply have to pay the other one money damages, so to speak. Whereas with criminal cases, it's a little differently. It's a violation of state law, and if you get convicted, punishment is applied. That's the difference between civil and criminal, is the application of punishment. Okay, so make sure you read the section in your textbook in regard to the difference between the civil and the criminal system. Now, the criminal courts, also called state courts, for the purposes of this chapter, in each state will have a trial court level, just like the federal courts do. They will also have one or more levels of appeals courts. And remember from last week, the appeals courts are not to rehash the facts of the case, but to look at errors committed during the trial in the lower court. If there were sufficient fatal errors committed, then the conviction could possibly be overturned or set aside, and then the defendant could be retried or simply freed and say this case is over. Or if the errors were for small or no errors were committed at all, then the conviction could stand, and you cannot appeal that through that court any further. You could go to a higher appeals court, because every state has some level of, like, a state Supreme Court. And then basically, again, it looks at errors committed during the trial, and if they uphold the conviction, your only other option is to appeal it to the U.S. Supreme Court, or SCOTUS, Supreme Court of the United States. That's really the only way that state courts and federal courts mix, is at the appeals level. They do not mix at the trial level whatsoever. State trials are completely autonomous of federal trials because the laws are differently. It's a federal law violation versus a state law violation. So make sure you read that as well. And if you look on page 89 in your textbook, there's a table there that gives you the names of the appeals courts in each state, kind of what they're called. Some states call it appeals, some states call it appellate, some states call it circuit court, some states call it commonwealth court, some states call it superior court. Some states do not have an appeals level of court. They just have a Supreme Court. So that's why I said it's a much more complex study of state courts than there is of the federal system, because you have so many different systems with different names and different types of courts within each level of state government. So I already talked about kind of that intermediate level of appeals that goes on into the state Supreme Court level. There's also a few other courts at the state level that do some different, very specific things, such as Justice of the Peace courts. That's mentioned on page 93. These are typically lower courts in rural areas, and the judge is typically called a Justice of the Peace. We usually see those still exist in states like Texas. They have a court system that's very much like that. They still have Justices of the Peace. It's a very court of limited jurisdiction that handles certain things in those counties, just to keep the upper levels of courts from getting clogged up too much. You also see municipal courts. I already talked about that early on here just a few minutes ago. Those are those city courts, or even very small county courts that just handle certain specific things like traffic offenses or something like that. Understand that as a case moves through the system, we look at the criminal justice system almost like an assembly line, and it's a step-by-step process as the case moves from one court to the next, or from one point in the process to the next. And that's just the way our system is designed, so that everybody's rights are protected. And we also have other specific courts at the state level, like a juvenile court system. The juvenile justice system is operated almost completely different than the adult system is. The juvenile courts are much more informal in nature. The quantum or level of proof beyond a reasonable doubt is still the same in the juvenile court, but again, it's much more informal. You don't have a jury in juvenile courts. The judge is a decider of fact, and also juvenile courts are not really there to issue punishment, but to find treatment modalities for the juvenile offender so that they don't become an adult offender. Now, they do mete out some punishment, but typically punishment is secondary in their juvenile justice system versus primary in the adult justice system. So the whole idea behind the adult court system is to punish the wrongdoer. The whole idea behind the juvenile court system is to treat the offender so that they don't offend again. Please read that section starting on 96 and going through 98 in your text on the juvenile courts. Other than that, if you can understand the structure, if you read this chapter and you can understand the structure of the court systems, you also need to read the section on court reorganization and court reform, because there's been kind of a call in the last several years for courts to be reformed, because there's been so many frivolous type cases heard. The courts have done some things that people don't think the courts should have done, or done things a particular way. They don't think courts should have done that particular way. So there has been a call for court systems to be reformed and more centralized and streamlined, and you can read that section in your text as well. But I want you to form an opinion on whether you think court reform is necessary or not. We also have, just in the last several years, initiated something called drug courts in this country, which it's almost kind of a misnomer, because a drug court is more than a court. It's an actual treatment program for people who violate the law in a non-violent way because they are addicted to drugs. So what they do is they bring the defendant in, they put them into a drug court process, and they put them through a very intensive drug addiction treatment program, work skills training program, and therapeutic program. Typically, at least one part of it is residential treatment, which means they can't leave, with the understanding that if they complete the program, then their criminal charges will be wiped away. The slate will be clean. However, if they fail out of the program, they may also agree that they can be brought back into court and sentenced more severely than they would have been sentenced in the beginning. So it's kind of an agreement. It's not really necessarily a court or a court system. It's kind of a multi-function drug treatment program that uses criminal charges almost as something to hang over the head of the addicted person to get clean, or else, is really what the drug court system is. And we've seen quite a bit of success with that program, that sometimes that's what people need. But it is included here because we don't see the drug court process at the federal level. We only see that in some states at the state court level. And your book actually goes into quite a bit of detail talking about this treatment approach as well as the evaluation of the drug court process on page 107. And I would suggest looking at that. Other than that, that's really all I want to cover for Chapter 4. It's really pretty simple and pretty straightforward. Don't get lost in a lot of the extra fluff that's in this chapter that's talking about all the extra courts, but please try to understand the structure of the system, the difference between courts of limited jurisdiction and general jurisdiction, as well as the difference between some of those upper level and lower level courts, what they can do, what they cannot do, and how they kind of fit into the whole big assembly line process of the criminal justice system. That's all for today, and I'll see you next week with Chapter 5. Have a good week, guys. Bye-bye.